Welcome.
This type of authority, a public safety and facilities authority. The bill requires a resolution of the governing authority of either DeKalb County or the City of Atlanta, as the case may be.
We are. We're on House Bill 259, members of the committee.
In the order in which they will be funded. So that, because as you know, whenever an authority funds projects go over the estimated cost all the time. Well, if a number of projects go over the estimated cost, then obviously some projects are going to get crowded out. And
Mr. Chairman, House Bill 259 ensures that any business or nonprofit organization that conducts a lawful promotion for the sale of goods or to further the purpose of the organization can only give away non-cash prizes. If you look at page 1, line 22, you can see where that's spelled out, thereby protecting the Georgia Lottery and not competing with its cash awards. Furthermore, the bill specifically provides that a person, if they wish, can enter this promotion, contest, or sweepstake for free without paying by buying anything of value. In fact, if you look at the samples that were given to you, you can see samplers of this type of giveaway that's going on at this present time. These types of promotions are commonplace in the state of Georgia today, but due to the recent federal Court of Appeals case, without the passage of this bill, companies and nonprofit organizations would be considered in violation of Georgia law. You have before you a letter from the Attorney General to me stating that the Court of Appeals case in 2004, which was there were two cases at the time. One was Piggly Wiggly, and the other one was AT&T. The decision of the Court of Appeals was that the company was assessed $1 million in punitive damages, and then it was later reduced to $250,000. This was for a contest that they were making no money on. This will correct that problem.
To have to go through this resolution and referendum process as
this
well.
bill
So
has no effect on the laws that govern the Georgia Lottery, the not-for-profit raffles, bingos, or bona fide coin-operated amusement machines. Mr. Chairman, I discussed this with the Rick Malone of the Prosecuting Attorneys Council, and they have no objection to it. They're completely familiar with it. If there are no questions, Mr. Chairman, I ask favorable consideration.
But it's something that is, with the rest of the bill, a very good fiscal accountability measure, and I would ask for the committee's favorable consideration. I'll yield for any questions.
Unlike this committee, not to have questions.
Mr. Les Snyder is here, Mr. Chairman, in case anybody wants to ask.
Thank you,
any
Representative
details.
Randall. We now have a question.
Yes,
Sure.
ma'am.
What change, if any, is the bill from the one last year?
There was a slight change that the prosecuting attorneys asked for, which it talks about 2 devices per location. This is, it seems that I believe on the borders they have some problems with people coming across from other states, and where they have mechanical or electronic devices. If they have such a thing, they would be restricted to 2 devices. And what this is primarily for selling phone cards, where you can take and insert the phone card to see if you've won any cash. That would be outlawed under this.
And limits this type
Further
of authority
questions?
to those 3 jurisdictions is general law. It's right here.
Further questions? Chair recognizes Representative Collins.
So this
recommend do pass
this
on this
provision
one.
has to be inserted in order for it to have effect. This
Is there a second to that motion?
Into that chapter.
We have a
That's
motion
exactly what this will do.
now that
A new section
House Bill 259 be given a due pass recommendation. Is there any discussion on the motion?
with regard to the position.
Any discussion? Hearing none, all in favor of the motion, please indicate by raising your right hand.
The city of Atlanta might take, other
I'm sorry.
than to say that it is my belief
Oh.
that any
Going back to discussion.
projects that might be funded by this
Legislative
type of
Council,
authority or the type
and
of
I
authority
should have done this earlier,
that DeKalb County
Did they find error?
found a
will be approved by the voters of
suggested
either one of those
amendment
jurisdictions.
on page 1, line 22, that we amend the bill to strike the words "as amended."
Certainly will be approved by the voters.
Since
of
the
either jurisdiction.
Internal Revenue Code section as amended
Right,
doesn't fit.
right.
I have no objection.
Okay. Is there any objection to that amendment? Do we need to do that in the form of a committee sub now, or can we just amend it and send it on? Okay. So we would now have a committee sub with that change. So, Representative Collins, I'll recognize you to withdraw your motion, and Representative Bearden to withdraw your second, and we'll start back over.
I wish to withdraw my motion.
Without objection, it's withdrawn. You wish to be recognized?
I wish to be recognized to make a
Representative Collins.
do pass recommendation on the substitute.
Okay. All right, now we have a motion, a new motion, that we give House Bill 259 a do pass recommendation by committee sub. Any discussion on that motion? Hearing none, all in favor, please indicate by raising your right hands. Thank you. All opposed? Thank you, Representative Geisinger. Well, that bill has been approved unanimously and will go on to the Rules Committee by committee sub.
Thank you, Mr. Chairman.
House Bill 50, a continuation of a discussion that we started in some depth yesterday with Chairman Forster. I had a lot of questions about this yesterday. You don't have as many people to question you today. Do we have Ms. Pittman here from the Department of Juvenile Justice?
Yes, sir.
Oh, good, good. Thank you very much. We may need you. All right. Chairman Forster.
Yes, sir. Thank you, Mr. Chairman. With some of the questions that came the other day, I've handed out, everybody should have a copy, a stapled packet of 6 resolutions of endorsement.
I have that somewhere. Here it is.
One from the National District Attorneys Association, one for the National Juvenile Detention Association, a resolution from the American Probation and Parole Association, the Association of Juvenile Compact Administrators, the National Center for Missing and Exploited Children, and CSG governing body itself. Also, I've passed out again the map showing that 31 states have already enacted this compact, this model legislation from CSG, and the next 5 will be the final voting members to be able to have input on the rules and regulations for the compact itself. So and there were other questions I've researched and I've got the answers for, dealing with the history of compacts, the nature, congressional consent, delegation of state authority to a joint administrative agency, and the reason we're doing this is actually avoiding federal interference. And I can go over those questions if they're still hot on anyone's mind, or if you wanted to go with the questions directly to the contract administrator, and we have others here from DJJ to answer concerns.
Questions for the author? Questions of the author? Representative Abrams?
I've gotten many of my questions answered.
Okay, thank you. Any members of the committee?
I'd like to reserve for Ms. Pittman.
Okay. Okay. All right, why don't we just have her come around now? How about that? I'm sorry?
I don't want to put her on the spot, but I would kind of like this compact, this commission, whatever, as opposed to if we were to sign on to this and join this group?
If Georgia makes the determination not to proceed with adoption, when the 35th state adopts, it becomes law, and it will supersede the existing compact. The first commission meeting will be convened to elect officers and proceed with adoption of rules and regulations. Georgia will have no voice at the table if we don't adopt.
That's exactly what I wanted to know. But when we adopt, prior to and we're included in the 35. That way we'll have a place at the table throughout the whole process, setting all the rules, all the regulations. We'll have a representative. We'll be represented through all of that stuff.
Exactly.
Right? Mm-hmm. And it has to be prior to, say if we were. What I'm missing is if it's just at 35. So say another state wants to join after 35.
It's not limited to 35.
It's not limited.
No,
to
35 is the threshold for enactment. And we, of course, certainly anticipate all 50 states plus some territories, adopting. The current compact has been enacted in all 50 states, the District of Columbia, Guam, and the U.S. Virgin Islands. And this compact is open to that and any other U.S. territories. So it could be the first commission meeting will be a minimum of 35, but it could be 37 or 38 states if that's who's enacted at the time the first commission meeting is called.
So the earlier you get on board, the more input you have.
Exactly. Exactly.
Thank you, ma'am.
You. Did you have one?
I do.
Okay. Vice Chairman Mumford.
First of all, I'd like to thank you for the work that you do with Interstate Compact. And I know in the past when I had to deal with Interstate Compact, your office was very, very helpful to me.
Thank you.
And y'all do a great job, sometimes under very difficult circumstances.
Thank
I
you.
appreciate it. One of my questions is, are there states that are refusing to enact this law?
Currently, I don't know that there's a state that has made a stance that they are refusing. There are states that have not moved yet for, I guess, a variety of reasons. Some of the questions I'm sure that have been raised and kicked around here.
Right.
Some, it has to do with financial impact. Some don't think the existing compact is broken, so why fix it? So,
Do you think the existing compact is broken?
If the rest of the country interpreted the compact and made an effort to enforce it the way I try to, we probably wouldn't have a problem. But we have many states that are not, they don't staff their compact office properly, they're not funded. We have lots and lots of problems with other states. I do my very best to keep Georgia as close to, doing the right thing as we humanly can. But like I said, we have some states that just are completely failing to fulfill their obligations. We've got a state right now that is, they refuse to return any kids that run away, escape, abscond. They're not doing probation supervision. We don't want their children here unsupervised. We certainly don't want to send our kids to another state and not expect them to be supervised properly. Particularly when we're dealing with so many clients now that are sex offenders and serious offenders. From a liability standpoint and the protection of the public, we want all of those kids supervised and, properly accountable back to the juvenile courts.
How many states does your office deal with? I mean, are you dealing with 50 states, or is there a concentration in the Southeast where you?
I deal with the entire country. As well as some of the territories. I mean, we don't get a lot of business with the Virgin Islands or with Guam, obviously, but I deal with, the entire country. I'm the longest serving interstate compact administrator in the nation, so I have, I know, I'm old. But, I tend to deal, and because I have been around for so long, I tend to do a lot of training for when new folks come on. I've served that juvenile association and all of the officer positions, currently hold an elected position with them now. But like I said, I've done a lot of training, so some states consider me, an expert. I certainly, from a historical standpoint, know more than a lot of folks, just because I've seen a lot of change and a lot of trends over the years.
Let me follow up. One of the things that gives me a little pause about this bill is that it has a budgetary provision for funding the commission, which it says in our cheat sheet here that it's at page 12, lines 17 through 20. And it essentially says that the commission will be able to hire staff. The states will fund the commission through an annual assessment levied by the commission on each compacting state to cover the cost of internal operations. The amount must be sufficient to cover the annual budget as approved each year. In Georgia, we really can't do that without having an annual appropriation, can we?
We currently pay dues to the Professional Association, the Association of Juvenile Compact Administrators. That portion establishes, instead of the existing AJCA, establishes that national commission. Mm-hmm. That commission will then oversee some of the administrative functions that we as elected compact administrators, when we work with that AJCA group, a lot of the function that we do in addition to our everyday jobs. Currently, I serve that group as the treasurer. I believe the proposed budget for the commission will have someone that does what I do as the treasurer for that group. Mm-hmm. It'll have somebody who handles all their accounting and auditing and that sort of thing.
Well, I think it would have been easier if they had called it something other than an annual assessment levied by the commission on the state.
And that could be. I was part of the rewrite committee when we met, when CSG and they put that group together. There was a lot of struggle with terminology and trying to get something that would be pleasing to all states. And I don't know that there's a way to do that, unanimously.
May I follow up one more time?
Sure.
Could you comment on the part where it says here, rules promulgated? I'm reading our cheat sheet again. It says this would be the bill at page 7, line 6, I guess. Rules promulgated by the commission will have the force and effect of statutory law.
Yes.
Can you sort of explain how that's going to work?
Mm-hmm. The current compact and the rules promulgated by the Association of Juvenile Compact Administrators have the same force and effect as federal law now. We have Supreme Court decisions that back that, and it's because of all of the compacts, all of the states have come together to compact. The governors have all designated people as their compact administrator to vote on those rules and regulations.
Can you sort of give me an example of what a rule might be that we're talking about?
A rule might have to do with a lot of it's procedural, has to do even like right now there's a lot of detention issues because different states view detention of juveniles in different ways, whether it's housing status offenders or probation parole absconders or escapees. So, you could have a rule that would mandate states when a juvenile is picked up as, say, an out-of-state runaway, a status offender, that a state would hold them in secure detention as opposed to a shelter pursuant to the interstate compact until that home state or the state that is seeking their return could get them back. Mm-hmm. And we do have a rule that's similar to that now. We even had to go so far before we promulgated that rule to seek an opinion from OJJDP that those kids detained, the status offenders, don't count against state totals when they report their detention of status offenders as long as they're being returned pursuant to the interstate compact. So that's an example. And it's to get kids, to hold them safe, to hold them secure, to facilitate their return or their supervision so that we can, enact the provisions of their court order, seek their return. It's for their protection and the public's.
May I follow up one last time, then
Sure.
I'll shut up for a while. You've been very active in trying to progress with our compact, and this is what we have here, what we're voting on is the product of your work. Is that correct?
It's the product of the rewrite committee. Mm-hmm.
And you've had input on it?
I've had some input in that, yes.
And are you satisfied with the work product yourself as our expert in this state, in this area?
My personal opinion is yes, I am. And I hope that that document, when it's enacted, does the things that we anticipate it doing. We have a compact that we're operating now that was written in 1955. It was enacted in 55. I don't have to say to this group that children and families are nothing like we were in the 50s. Have been insured by many, many groups. I mean, we had a group of stakeholders. We tried to, to Band-Aid and fix the existing compact without going to this step of trying to rewrite. And I was a very strong advocate of not rewriting to begin with. And it just became evident, the more we talked, the more the stakeholders were at the table, that we couldn't fix the existing compact. You can't make an old car, brand new. I think we have done the best job we could to give us a good vehicle to see us into the future.
Thank you very much.
You're welcome.
Representative Collins.
Thank you, Mr. Chairman. I have just a couple of questions concerning one. I think in looking over this large piece of legislation, I think probably the intent behind it and all seems to be very good as far as moving us along. I think the scale of it, and with some of the questions and comments we've heard, especially given the fact we're voting for a compact that rules are not promulgated yet, that we are sort of still looking for. One question I have is, what is the current, and I'll use the language of this new bill, the annual assessment levied currently? How much is our dues?
We currently pay $400 a year.
Do you foresee this amount going up tremendously?
The proposal that is in the package that y'all were given a copy of is different state to state based on state population, offenders, that kind of thing. I believe Georgia, in the model that CSG proposed, was $27,000.
We're going from $400 to $27,000.
That's the proposal. Now, but we have no office now. I mean, we have no staff now.
Okay.
The services are provided in kind.
Okay. So, and this may be my next question. I apologize if this seems to be going back, but we've been asking questions among ourselves. The question I have is the history here. Mm-hmm. Did this come in the 1950s as a program Congress said, hey, we need to do this, or is this the states coming together and saying we need to do this?
It was the states came together, as I understand it. The move to draft the compact came in the I think about 53 to 54. There was a series of articles written that was in Parade magazine, and it had all to do about the plight of the runaways. And there was no formal mechanism to return kids or to supervise kids across state lines prior to that time. It could be anything from a law enforcement officer picking a kid up and just driving them, putting them in a truck with a truck driver, and dumping them out somewhere. So it was states coming together and stakeholders who realized that there was a need to have a formal process to return kids and to supervise kids is what prompted that. So it wasn't federal as I understand it.
Okay. Mr. Chairman, can I follow?
Sure.
Okay. I want to go back to this 400 to 27,000. And I'm just asking because all of a sudden we go to 400 to 27,000. I understand you're going to make an office and this kind of stuff. And this will be where would this be in Washington?
Well, the commission will make that decision. The adult system just went through this process about 3 years ago. I guess that they finalized and got all of their states together. They are housed in Lexington, where CSG is.
Okay. So, and did I hear you correctly? Is this 27,000 a guess, or has this been sort of written down that this is what it's going to be? I'm trying to say if we haven't had the rules yet, mm-hmm. How do we have the 27,000 figure?
The 27,000 was the figure that CSG put together. That's where Georgia falls. Like I said, there are some states that are more, some that are less.
Okay.
And they have a formula based on, there's about 4 or 5 things, but state population, offender numbers, that kind of thing.
And these formulas were based on what year?
Golly, I think probably 2003 or 2004.
Okay.
The adult system is involved in their adult compact, and they do pay whatever their appropriate, assessment is.
Okay. And just one final question. I just want an assurance, because like I said, I believe this bill is probably a needful bill. It's just, again, a lot to go through, and especially with the question of sort of that came up yesterday, we're not knowing what the end result may look like. And I even heard in your comments, I thought, even some reticence that you're not, you think that they may, but then again, we may get into this and the rules that you're hoping for does not turn out.
You're talking about the promulgated rules?
Yeah, the promulgated rules may not turn out as you would want them to turn out.
The promulgated rules, the association has rules that are promulgated at this point. Mm-hmm. And we're certainly hopeful that the commission will adopt the existing rules, at least as their starting point. We've taken, over the last couple of years as an association, we've made a very concerted effort to rewrite our rules. We presented those to Rick Masters, who is the legal counsel for CSG. He worked very closely with us to make sure that our rules were legally sound and well written, so that when we get to that point, that the commission could adopt those, at least as their starting point, even if there's a decision to be made to make some changes later on.
So we're not starting with a clean slate?
We're not, yeah, and that's the rules. The assessment is something separate from that.
Okay. All right. Mr. Chairman, thank you for your indulgence.
Thank you. Representative Setzler.
Thank you, Mr. Chairman. Again, thank you for coming today to talk to our committee. I have a couple of questions, and I wanted to ask you a question I asked yesterday, but I'll ask another one first. Under the current circumstances, is our system broken and are kids being hurt?
Are our kids being hurt? We have kids that are not supervised. We have kids that we are having to take extraordinary measures to return to their states because their states don't fulfill their obligations. Mm-hmm. So when you're talking about that neglect of services, yes, I believe there are kids hurt.
So you think there's a real problem here that needs to be solved? It's not just in Georgia; it's in other states as well.
I think it's national. I think there's not a lot of attention, oftentimes, particularly on kids that move across state lines.
If this is such an issue, how come the federal government, the United States Congress, is not taking action on this?
I can't even answer that for you.
What argument could you make that this is something that ought to be done in the context of this complex interstate compact that would convince me that it ought to be done through a compact as opposed to a single action of Congress?
That's like a loaded question, isn't it? I don't think states want the federal government to step in and take hold of this. I mean, I think we want to hold on to our states' rights and us have a voice at the table. If the feds take it over, no telling what will happen then.
I am an overwhelming supporter of states' rights. Mm-hmm. I mean, I am a states' rights person if there's one in this Capitol. I guess the question is, we've got 13 representatives in Congress. We've got 2 senators. I don't know why we would bind ourselves to 35 other states where all states have one vote and there's this new construct and where money's flowing to some organization to set up a coordinating center. I just don't understand why this mechanism to do this. It just doesn't seem to be the best, most effective way to address this issue, and particularly to the extent we're entering into a compact where we don't know what the answer is going to be yet. We don't know what we're buying. We're bidding on what's behind door number 2, but when the door opens up, we don't know if we're getting the car, if we're going to get the trip to Hawaii, what we're getting. There just seem to be so many uncertainties, and I understand the argument of a place at the table. I've not been convinced in anything I've heard that the way we're proposing to do this through House Bill 50 is the best way forward. And I'm asking you to persuade me.
Again, I would go back to the fact that if we don't go forward, we won't get door number 1 or door number 2, either one. That's my fear, that we get the door with the booby prize. If we don't adopt and we're not at that table, once those 35 states adopt, for Georgia to continue to do business, to move our kids across state lines, and more importantly, to supervise other states' kids, we're going to have a memorandum of agreement with all of those states in order to conduct business. I don't know about you, but that seems very overwhelming to me. I don't want to see us get to a point that our kids are totally not supervised, or that we leave our public unprotected because we don't know other states' kids what we're getting. Those kids are dumped in our state with no supervision.
And again, my concern, Mr. Chairman, I'll wrap up. This is my last question. It seems that the United States Congress has been so intrusive and so activistic in terms of getting into the state's business over the last, you pick the period of time, it would seem if this were a real problem, it would have been addressed. Has there been any federal action to address this issue that's failed and hasn't passed, or has this just been something the federal government's been silent on?
Yeah, someone else may could answer that. I can't answer that. I'm not certain.
Representative Abrams and then Chairman Cooper.
I have a series of questions for you that I think are mainly yes or no, but I think may get to some of the concerns. First of all, this is a 50-year-old or 52-year-old compact, is it not?
Correct.
So 52 years ago, individual states determined that they preferred to come together and determine what the rules would be that would govern how they interchange children amongst the 50 states and the 3 territories and the District of Columbia, correct?
Correct.
The compact after 52 years has come under some scrutiny because it has not evolved with the times and the changing nature of our children and the changing nature of juvenile justice and their status moving across state lines.
Correct.
The compact will take effect regardless of Georgia's action on the matter.
As soon as the 35th state adopts.
And the compact will take effect and will have primacy over individual state laws because of the Supreme Court decisions that recognize the 1955 compact that's been in effect for 52 years.
Correct.
That absent passage of this bill, we would have to then, and if we do not become the 36th, 37th state, absent passage, if we decide to opt out completely, we would then be required to negotiate 52 separate agreements, which may or may not have consistency across the states that we're negotiating with, and we have no system in place currently to negotiate those because the system that has been created is this compact system.
Correct.
And that Georgia is the 4th most populous state in terms of juveniles who are impacted by the system after California and Texas and Florida, I believe.
Correct.
Thank you.
Chairman Cooper.
Representative Abrams was making the point, I thought, since Representative Setzer came in late, I hadn't realized before myself that we were already operating under a compact like this, and that this basically is just an update of a very old compact, one that has worked for 50 years,
yeah.
Except that it's become antiquated with the changes in our society and our families over a period of time.
Exactly.
I thought that might...
We did spend an hour on this yesterday, Chairman.
I'm sorry. Okay. I didn't stand corrected.
Okay. Chairman Knox.
Have we vetted this bill in light of House Bill 1059
I'm not sure what that
from last year? Well, my question, because one of the problems with that is if you have a sexual predator, and I think a child can be a sexual predator if they're even if they're 14, if it's an adult offense, and they could be declared an adult for purposes of that offense, if I'm not mistaken, if it's an offense an adult could commit or would commit. And they're in our state now, we've got some pretty tough laws with respect to sexual predators. In other words, they, as far as wearing monitors and, that sort of thing. But this, as I read this, that they wouldn't, the state that has the person in custody, if I'm mistaken, tell me I'm wrong, has the person in custody, doesn't have to send them to us if the crime, they don't have to enforce rules in their state unless it would be a crime in their state and they would have the same rules, I suppose, is the idea. So if their state doesn't have a requirement that they have a monitor and that sort of thing, they don't have to have a monitor if they go to that state.
Exactly. Right? And it's just like if our kids, if we have a sex offender who goes to another state, we don't do juvenile registration currently in the state of Georgia. If we send a child to a state or a young person to a state that does have juvenile registration, our kids are required to register there. Nationally, the age that people look at juvenile jurisdiction runs the gamut from expiration at the age of 16 up to the expiration of age 25. We always look at the age and the jurisdiction in the home states when we determine supervision, and we also look at enforceability of the laws of both states, the rules of both states.
So if there's any conflict with the sexual offender law that we just passed, and this law is going to take precedence. The compact law is going to take precedence for that. Is that it?
I would say that would be, determined by the rules. And I'm not familiar with that law, so I'm, hesitant to try to.
All right. Let me ask you on page 24, at line 29, we're talking about 151191. I'm not sure I know what this means. There's a provision to the part shall apply only to cases and circumstances in which the provisions of Chapter 3 or 4 of Title 39 do not apply. Now, I have to Beth, I don't know what Chapter 3, R4, R Title 39 have anything to do with.
I believe that's where the existing interstate compact law, it's at 39.3, and then continues on. That's where the existing compact law is.
And they're wanting to move
And
it to
the juvenile court code, because it's not currently in the juvenile court code.
Okay. All right. Now, last is when we saw this bill, I think it was last night, we had it seemed like it was a larger bill. It had some other legislation on there. Was a question about that. Have we resolved that about something the DAs want to do, something like that?
No, that's still in there.
It's still in here?
Yeah, that's, you got copy number 2.
Yeah, I have.
That's the prosecuting attorney's update for the international portion for juveniles.
Okay, that's actually a separate piece of legislation, but it's stuck in here.
Yes, sir.
Do we have the same concern about implementing it as we do with implementing? We don't currently have that in the 1950s.
We have no international provision currently.
Is that a problem for us now, or do we need it in order to update the compact?
The Prosecuting Attorneys Council has had some cases that have come before it where children from other countries have ended up in Georgia, and we've had no mechanism to legally to get them back. No assurity that if we send them back that they get there safely, that kind of thing. That's where their request for that legislation has come from.
Thank you,
I have just a couple of questions. Does it give you any pause for concern that there's some oversight being shifted here to the federal court in Washington to monitor this commission?
Now, and maybe if I'm mistaken, I apologize. I don't believe there's any federal oversight. That would only be if it went to some sort of arbitration.
Where's me a copy of the bill?
Number 2.
Where's number 2? Right.
The district court.
Yeah, the district court.
Federal district court. And that would only be if there was some issues that could not be resolved with the state council, with the state council, and only then if it was sued.
Does that give you any concern?
No, not really.
Okay.
I hope we never get to that point. That's,
sure,
you know,
I understand.
that's my goal, that we never see that that's never an issue for our state.
Before I ask you this question, let me ask you, have you followed the progress? I understand that we are up to, 30 or 31 states that have adopted this now, and that's been over a 5-year period, correct? Mm-hmm. Have the states that have adopted this done so in any cases by amending the Model or Uniform Act, or do you know?
The previous compact, the original compact, or the language that we're looking at today?
No, the language we're looking at now.
There may be some slight alterations, but in essence it should be the same.
Okay.
There may be, like I said, a few words different.
I'm thinking about an effective date.
Mm-hmm.
How would it be feasible to do an effective date that would say that this would be effective at such time as the rules have been drafted by this first 35 states, and we look at the rules?
From my personal standpoint, I don't think that's feasible, because I would want us to be one of those 35.
Well, we would be in terms of passing it.
Mm-hmm. But I think, if I'm not mistaken, there's a clause in there, and I'm not sure where it's at, that at any time after rules are promulgated and made known, a state can renounce.
Okay.
And the one thing, just...
And I guess yeah, go ahead.
I just wanted to say, one thing we don't want to do is repeal the existing compact the day of the 35th state, if we happen to be one of those, mm-hmm. because we do need, some transition time for everyone to get on the train.
Let me ask you this, because if I heard your testimony accurately, you indicated that you felt like the primary problem with the existing compact was the failure of the states, some states, to uniformly follow it.
Administer. Mm-hmm.
Administer it. Is there anything in the proposed legislation here that would ensure that they're going to follow the new one any more than they have the old one?
The existing compact has no enforcement piece.
Mm-hmm.
That's, the big problem. And that's the reason the portion is in there about the state council, because that would be why you would have a commissioner that would, oversee the compact, to administer the compact day to day. You would have a state council that would also have some oversight within our state that's made up. The law specifies the minimum parties that are to be part of that state council, but that's that committee's responsibility. If another state should lobby a problem with us, if they should come forward and say there's a problem that can't be resolved between the two compact officials, that state council is expected to step up and help to do that resolution before it would go to that district federal court. So that is, that's where that enforcement piece came in.
Mm-hmm. Okay. Further questions from the committee?
I've got a question.
Wait a minute. Representative Byrd has one.
Okay.
Thank you. I'm looking at this map, and we're talking about 31 states that are involved in this compact now. Why is it that the two most populous states, which are California and New York, not coming to the table or opting into this compact? My second question is, when the original compact was done back in 1955, how many states were involved in this compact?
I was trying to think how many adopted in 55. I want to say about 13 or 14, New York being one of the first states. I'm not sure what California's hesitation has been adopting this compact. I was contacted probably a year before last now by one of their someone from one of their legislative branch for some information because I was listed as part of that rewrite committee. What happened to it from that point, I know the California Youth Authority, who has responsibility to administer the compact, was moved under the Department of Corrections. They've now kind of been pulled back out into still a subcommittee of corrections as a juvenile justice agency. And whether some of that got lost in their shuffling that agency back and forth, I'm not sure if that's the problem or what.
So we still, you said back in 1955 that there were 13 states.
I believe 13. I may be incorrect about the number.
So right now, though, whatever compact we're functioning under, how many states are involved?
All 50 states, the District of Columbia, Guam, and the Virgin Islands.
Thank you.
Mm-hmm.
Vice Chairman Mumford.
This bill seemed to cause some consternation in the committee that I think you've done a great job of allaying that consternation. I'm a little concerned about if the bill gets on the floor, whether some of that confusion may arise again. Is there anything magical about having the district attorney's language on the back of this, and might it be better to separate that out and have two separate bills to try and keep the confusion to a minimum?
Are you speaking to the international portion?
Right.
I think speaking to it separately would be in our best interest. I mean, that's my personal standpoint. I think it's two separate issues that should be looked at and weighed carefully.
Right. All right. Thank you very much.
Further question, Representative Setzler.
Thank you, Mr. Chairman. And again, to the lady testifying, I apologize if I came across or if I was, in fact, too direct before.
No problem. I'm tough.
I just, and I apologize to the committee. I would like to share, Mr. Chairman, and I want to confirm before I make another remark. I'm reading on page 14, lines 19 through 21. I just want to clarify the meaning of this. I read, again, I'm working on version 2 of this bill, the 2718 ERS version. This compact shall become effective and binding upon legislative enactment of this compact into law by no less than 35 of the states. The initial effective date shall be upon enactment into law by the 35th jurisdiction. Thereafter it shall become effective and binding as to any other compacting state upon enactment into law by that state. So if we were to pass House Bill 50, We would enter into this group of 35 states. Rules would then be determined, and which we would then be able to participate and vote in. But once they were decided upon, it would be binding on the state of Georgia as it would have the force of law. Is that correct?
And never how many states have adopted it and enacted at that point, yes.
So what we're suggesting here, and I've tried to think of an analogy and I've failed to think of a good one, but what we've decided is, and we're talking about our children, we've decided that it would be akin to, to the extent the state of Georgia, in my analogy, is like our family. It would be like my family deciding we're going to get together with 35 other families, some of whom we know we don't agree with in terms of how they raise their kids, some of whom we probably do. But we're going to get together with 35 other families and get together and talk about how we're going to raise our kids. And whatever the group of 35 families decides, we're all going to raise our kids the same way. We're all going to do things exactly alike. Now, certainly it's good that we're able to participate, but whatever we agree on, everyone is bound to. We don't know what that's going to be yet, but we're going to be bound to it. Now, when you personalize it like that, it's a little tenser. But in essence, the issue is we don't know what that discussion is going to end up being. But by passing this, we will be bound to it. If we were to wait, we could either accept it if we liked what it looked like, or if we didn't like what it looked like, presumably we wouldn't like it for a reason. And then we would be in a position to have to bureaucratically establish different agreements with different states. But that might be a better position to take than agreeing to something we don't like. And we could make that decision then when we knew what it was we would be agreeing to. I think we're binding ourselves to something we don't know what it's going to be, and I don't think it would be responsible for us as a General Assembly to do that.
That's exactly where we're at now, though, sir. We entered into a compact when Georgia adopted in 72. The compact was written in 55. Georgia adopted in 72. We were bound by whatever rules were in place at that point. Every year when we go to our compact meeting and we propose new rules, as much as we work on them before we get to our meetings, when we get there, then it's a whole nother struggle, another family meeting. So we're bound by those existing rules now. So whatever rules we have today, whether we like them or not, as long as that compact body that was at the table and voted, as long as we had a quorum, we're bound by those rules whether we voted in favor or not.
I hear that, but what we're doing is we're reinitiating a new compact that we would be bound to. And this is an opt-out thing. If this were an opt-in thing, if we were saying, hey, we want to be part of this team to help determine what this is going to look like, then an action of General Assembly would be required to get us into this compact. I'd say it makes great sense because we want to be at the table. But what we're doing now is we're binding ourselves to this. It would have the force of law that we would then have to pass another law to get ourselves out of. And until such time as that happened, we'd be bound to it. We might not like what it was.
Yeah, and I see that that's it's going to be the force of law. Within 12 months after the 35th states, we'll have no compact at all.
And it's to that point, Mr. Chairman, I appreciate you being here. I won't be supporting this, and I would encourage the members of the committee to be very careful about supporting it.
Thank you, Representative Sessler. Chairman Knox.
Would you direct me to where the so-called international compact is? And what bill are we working on? Are we going with version 1 or version 2 that has it?
It's version 2, LC 292718 ERS.
Okay. And does that have the international compact part?
Yes, the part 2 on page 19.
Okay.
I believe it's where it starts the part about where you ever see lines. That's the international portion because those lines indicate our current law and the changes for the international portion.
I'm trying to understand that. The underlining is added language to the current compact, and all that's underlined is only the...
Not to the current compact, to their current portion of Title 15 for dealing with another state to update it for international.
There currently is language that you're addressing that allows the state to enter into some transfers across state lines utilizing the Uniform Juvenile Court Act. those transfers currently are binding only among the states that have adopted the Uniform Juvenile Court Act. That is separate and totally apart from the Interstate Compact. Now, we have compact law in Supreme Court that says anytime you've got a law that's in conflict, the Interstate Compact supersedes. So, again, from my personal, humble opinion, we should have taken that out of our law way back when. The Uniform Juvenile Court Act, those few provisions are binding only among the party states. I think there's 4 or 5 states in the nation that have that specific language. This international portion has been written into those sections.
So here's my question. I'm thinking that we may want to consider taking out the international, or at least I'm considering a motion to take out the...
Let me jump in. I may help you out here.
Right.
And I don't want to put you on the spot. Maybe the author of the bill can help us. But in our folders today, we have 2 versions of this proposed bill. They're both subs.
Yes, sir.
One has up at the top marked with the number 2, and that's 2718 ERS.
Yes, sir. As the committee would recall...
Let me finish.
Yes, sir.
My understanding is that has the international language or provisions with the language that were suggested by the prosecutors. Then you have version number 1, also in your folder, which is LC 380283S, which does not. Now, is that accurate? Sally, you may need to help me. It does have it in there, too.
Yes, sir. I believe they both do.
Okay. All right.
Committee recall when I first came in, Jill, legal counsel, found some grammar errors to redo, and her redo of the subcommittee's work that added the international version is copy number 2. Copy number 1 was the first from the subcommittee, but Jill found some grammatical errors, and that is number 2.
So Sally, I'm going to defer to you here, and Bill. We really need to be working today from number 2.
Yes, sir.
Okay, so we can disregard number 1.
Disregard number 1,
okay.
LC 2927.
Now I'll recognize Chairman Knox for his comment or question.
All right, so then my question is, what is it that we need to do to this, if you can tell us, to strike the prosecuting attorney's addition to what we need? Because I'm with Chairman Mumpert. I think we don't need to confuse the issue any further than it is by putting stuff in we don't need to get the compact running, if we're going to do that. I mean, if we're going to run the compact, that's one thing, but putting the rest of that stuff in there, I'm sure is not helpful.
Yes, sir. I believe it's parts, let me get this, I believe it's parts 2 through 5. And I believe the subcommittee chairman asked for the international portion. Part 2 on page 19. Where all the line out and underline stuff goes through page 20, or excuse me, page 34.
I think, are you looking at, which version are you looking at?
LC 292718 ERS.
Okay, well, the reason I'm asking is because part 2 begins with section 2.1, which says that it's amended by repealing chapter 3 relating to the Interstate Compact Act. So I don't think you want to strike that out of this version.
Oh, beg your pardon. Let me see. That was updating the change. Excuse me. That was updating the change in the position for the compact. So that would be part 3. 151186. Yeah, part 3.
I think the original one we had didn't have international. I didn't bring it.
where it says country.
Not three. Sure that solves the total confusion.
Looks to me like
Recognize Chairman Knox.
looks to me like part 3 is what you want to excise. That's where you start talking about what country means, what a foreign country is, what an Indian tribe is, and all that business.
Yes, sir.
But I see not all that is underlined. That means not all that language has been added. Usually that means only the language that has been added that is underlined.
Right.
So would we just be striking the language that's underlined when we're taking out the recommendation to the...
Oh, we can just get rid of that part because we're not going to be changing that part of the international code or adding to the international code.
I'm not saying about the GR. I have no appropriate time to determine.
Okay.
Just a minute. If we leave the international part in, that doesn't involve the United Nations in this in any way, does it?
Not that I know of, sir.
Okay.
But
Chairman,
Legislative Council knows the language that they added for the prosecuting attorney,
okay.
sir.
Chairman Knox, did you ask to be recognized for a motion?
I did,
But now you've changed your
I
mind.
haven't second thoughts, Mr. Chairman. I really don't know what to do.
Further questions, comments from the committee? Representative and Senior Hawk, Lunsford.
I think this is really for Chairman Knox. When you were asking about what effect could it have on our sexual predator law, I think you'll find your answer on page 17, line 20. And please correct me if I'm wrong, but I think what it's saying is all compacting state laws other than state constitutions and other in-state compacts conflicting with this compact shall be superseded to the extent of this conflict. So I think that fairly explains that this compact will take precedence over our state laws. Yes, sir.
And I think that was maybe the response that Ms. Howell gave us yesterday on some things. Representative Collins.
Mr. Chairman, I'd like to be recognized for a motion, appropriate time.
Any further questions? I'm sorry? Okay. Then I'm going to hold off recognize you. Representative Abrams, did you wish to be recognized? Representative Abrams.
And this is actually a bit in response to Chairman Knox's concerns about sections 3 and 4. It would seem to me that 3 and 4 are included only to the extent that you need to make revisions to that language, so that if you were to extract that language, those would be settled pieces of law that wouldn't change. So that if you wanted to only focus on the compact and remove the interstate components, you would strike part 3 in its entirety and part 4, because those two parts are only included in this in order to add the language that refers to the international components. But if you don't speak to those, then it remains the settled law. That is what's currently on the books, so you're just not touching it.
I'm just confused why only part of it, if this was added to this compact, and it's not part of the compact itself, why is only part of it underlined? The rest of it, my understanding of construction in this is that if it's not underlined, if it's not crossed out, then it's the existing language.
Correct.
Okay.
And the existing language does not speak the existing language is silent as to the international components that this tries to address. So we would just enter into this compact without ever addressing any of the international components, which is basically what's been happening for the past 52 years.
I wanted to exercise the prerogative of the chair because Ms. Amy Howell, for whom I and all the members of this committee have great respect, is wanting to be recognized. Maybe she can enlighten us here on day 2.
I think I might be able to clear up just in terms of the underlined sections, which I think are your questions. I believe the international language is in sections 3, 4, and 5. Section 6 speaks still to the interstate compact. And I believe the the reasons that the rest of the sections are not underlined is because it's all new language that would be added to 1511, because the interstate compact currently resides in Title 39. So that would be the reason. I think that might clarify.
So if we strike 3, 4, and 5, we'll be taking out what
The international.
the international constitution. Thank you.
Okay. It's never the chair's intent to cut off good, healthy discussion and debate. So are there further questions? If there are not, then the chair's intent is to recognize briefly the author of the bill for any final comments if he chooses. And if he feels like that he and Ms. Pittman have sufficiently explained this matter to the committee, then I will make inquiry as to the pleasure of the committee.
Mr. Chairman, I think Ms. Pittman has been very clear.
And I think you better find a way to bring her to the floor if this bill makes it to the floor to explain it. You did a good job, Chairman Forster, and I appreciate you. And Ms. Pittman, I don't know what the committee's going to do today, and we may see you again, but I want to thank you for your time. You've been extremely helpful.
My pleasure. Thank you.
I had indicated Representative Collins. I would recognize him. May I?
In my role, I will defer to the chairman.
You're an intelligent member of this body, Representative Collins. Chairman Knox.
I'd like to be recognized for a motion, Mr. Chairman.
You're recognized.
I would like to make a motion that we excise and remove from this bill that section 3, 4, and 5 in order to remove the component relating to international, whatever we call it, international whatever. Anyhow, that's my motion.
Renumber part.
And renumber.
Yeah, and renumber.
Remove the UN part.
Right.
Okay. All right, and renumber. Does everybody understand that motion? Representative Lunsford.
Yes, sir, Mr. Chairman. If we make this motion and it succeeds, we will also have to address Section 6, the numbering there where references the enactment date of Section 2 and 4 and 3. And so we can do that with an amendment if this one passes to renumber that.
Sure. Representative Collins.
Okay. I want to be clear about this. If we go ahead and strike this out of this bill, if this is an essential issue, Chairman Forrester, I know that it was part of your bill to start with, he could then readdress it as an individual bill. That is correct.
Yes, this portion was put on in the subcommittee. It was
okay.
It was not my doing.
Okay. That's all my questions. Thank you.
Does everyone understand the Knox motion? Is there a second to the? All right. We now have a motion to amend LC 292718 ERA. I'm sorry, LC 292718 ERS. Yes. Yeah. The Knox motion, which would strike sections 3, 4, and 5, renumber, and make the appropriate changes in the title. Is that sufficient for your purposes on that? Okay. Does everyone understand that motion, which now has a second? Is there any discussion? Hearing none, all in favor of the Knox amendment, please indicate by raising your right hand. Any objection, raise your right hand. There is no objection. The Knox amendment is adopted. Representative Lunsford.
Yes, sir, Mr. Chairman, I'd like to be recognized for a motion for amendment.
Sure. You're recognized.
Section 6, since the Knox amendment has passed, we need to amend the bill as amended on line 5, which says parts 1 and 4 have passed become effective July 1st. We need to remove the terminology in case
before I...
Because we'd still need the effective date of Section 6. So we would strike it all the way to where it says, and Roman numeral 6, and then we move forward with 6 shall be effective July 1st, 2007.
Before I go shopping for a second, Madam Legislative Counsel, do you understand the Lunsford amendment? Is it appropriate as stated? Sure. Okay. Is there a second to the Lunsford amendment? We have a motion by Representative Lunsford to amend, as has been stated. Is there any question, first of all, about the Lunsford amendment? I'm sorry, Representative Abrams.
I just want to be clear.
Sure.
So line 5 would read Part 1. We would strike the S in part, word 1, and then strike and 4. Then dropping down to line 18, we would strike it in its entirety 18, 19, and 20. And then line 21 would become Part 5 shall become effective. And that would be the...
Part 3.
It would have to renumber.
I'm sorry,
Part. No longer Part 5.
Right, Part.
Now it's a Part 3.
Part 3, sorry.
It would have to renumber.
So you would strike the part, you'd strike and, so you'd strike the S in part, and you'd also strike and 6.
No.
Yes, ma'am.
Okay.
And that was why I was asking if Lake Council could
That was the agreement.
number it accordingly, because we just took out 3
I just
sections.
wanted to, thank you.
Further questions or discussion on the motion to amend by Representative Lunsford? Hearing none, all in favor of the Lunsford motion, please indicate by raising your right hand. Any objection? No objection. It's adopted. What's the further pleasure of the committee? I'm sorry, Representative Abrams.
Although I will defer to my colleague, Mr. Collins, who's been trying to make the motion.
No, Representative Abrams, you go right ahead. You were recognized first. As much as this has been, you go right ahead, ma'am.
I would move to pass,
And I'll second.
as amended, and substituted.
We have a motion by Representative Abrams, seconded by Representative Collins, let the record reflect, that we give House Bill 250, version 2718 ERS, a due pass recommendation by committee sub as amended. Is that correct, Legislative Counsel? House Bill 50. Is there discussion on that motion? Is there discussion? Hearing none, the chair will call the question. All in favor of the motion to do pass House Bill 50 by committee sub as amended, please indicate by raising your right hand. Okay. Did you get a count, Diane? All opposed, indicate by raising your right hand. Okay. It appears to the chair that the motion has carried, although with some dissent. So we will send that on to the Rules Committee with that recommendation, Chairman Forster.
Thank you, Mr. Chairman. I really appreciate the due diligence and fine-tooth combing of this committee.
I hope you found your visit here to be a most worthwhile experience.
I'm going to go home, go to bed, Mr. Chairman.
He's not allowed to come back, is he?
No. Now he has. That's his one bill for the session in this committee. Second. Once again, we're at the end of the week, and I understand we're going to be here Tuesday, and I am assuming we will be here Wednesday and Thursday, although I further understand that nothing here is for certain anymore. I'm thinking we're going to meet again as a full committee Wednesday and Thursday of next week. I am going to encourage Chairman Knox and Chairman Mumford, if they can at all on Tuesday, to have maybe try to have some subcommittee meetings, because I know you guys are getting backed up. So, and when they schedule those, I would encourage members of the subcommittees to please be in attendance. We're getting at a very, very critical time here in the session. I've got 2 or 3 brief assignments to subcommittees. I'm assigning House Bill 26 to Subcommittee 1, the Knox Subcommittee. I am assigning and let the word go forth, Senate Bill 23 to the Mumford Subcommittee number 2, and Senate Bill 34 also to the Mumford Subcommittee number 2. Any questions? Meeting's adjourned. See you all next week.